All right, I'll just, yeah. Okay. Hello, everyone. I'm Dan Harris, and I'll be doing most of the talking tonight, but for the Q&A session, Steve will be up here as well. We've been talking all day, and we gave a full talk about an hour before lunch, so I may repeat a little of what we talked about earlier at lunch, but it will also be different. G introduced this talk as protecting your IP from China. I've expanded it a little bit because that's what we focused on before lunch. So this talk will deal a lot with protecting your IP in China, but it will also deal with the legal issues involved in outsourcing your product for manufacturing in China, and what can go in your contracts and why your contracts matter. So in, well, let's see. Yes. Okay. So in outsourcing your product manufacturing to China, I always talk about there being three keys. Number one, structural protection, which I will explain. Number two, having a good contract. And number three, good registrations. If you want to add a fourth one, it would be quality control. So what is structural protection? Well, the first thing is having a good partner. Generally, the better your partner, the more likely it is that they're not going to steal your IP, and the more likely it is that you're going to get good product. And when I give this talk, I'm based in the States, Steve is based in China. When I give this talk in the States, I spend 10 or 15 minutes talking about how to choose your China partner, how to conduct due diligence. I'm not going to do that here for a couple of reasons. One, you're all here in China, so I'm going to assume you have considerably more knowledge on that than the people before whom I speak in the United States. And number two, many of you or most of you are working with HAX, and HAX is very much ably equipped to help you choose the right manufacturer. So I'll briefly just say it's a good idea to choose a good partner. You all know that. It's a good idea to conduct due diligence in China. And due diligence in China, like just about everything else in China, can itself present its own risks. It's not necessarily like conducting due diligence in Europe or the United States. One of the reasons is because a lot of the things that you do to learn about a company in the United States or in Europe may actually be illegal here. There was a private investigator who spent 2 or 3 years in jail. I think he very recently got out because he did a little too much investigating, and you have to be careful about that. The other thing is that whatever you look at can be faked. Everything in China can and has been faked. So you can get documents from a Chinese company and they might look good to you, but they might be completely fake. And so what we always are certain to do is we double check the documents. If the company gives you registration documents, look them up online, see if they're really registered. All sorts of documents that can help you figure out whether you're dealing with a legitimate and good company or not. If you're not dealing with a legitimate and good company, they may be fake, so be aware of that. Okay. So I talked about structural protection, I talked about due diligence. Another area of structural protection is with your IP. As lawyers, our job is to help you legally with your IP. That means good contracts, it means good registration. But oftentimes, you're in the best position to protect your IP, meaning that we can write the world's best contracts, but again, if let's say you're dealing with a crook, we'll violate the contract. The other thing to always think about is what can you do to protect your IP outside of the legal arena. And if you're a big company and you have a lot of computers and a lot of employees, there are certain things you can do with respect to maintaining the security of your computers. That sort of thing can be very helpful. There are a lot of things you can do with your product to help protect it from being easy to rip off in China. During today, we spoke with a lot of the HAX companies, and a lot of the HAX companies are doing this. What they're doing is they'll have a product that's a hardware product, and it has a software component. And rather than put the software component in the hardware product, they'll put the software component on the cloud. That's a structural protection, because if somebody knocks off the hardware product, they're really only getting half of the overall product because they don't have the software to go along with it. And there are various things like that you can do. And it really varies with the company, and you're in the best position to know how to protect your own company. And I always like to bring that up because it's surprising how often companies, once they hire a lawyer, just look to us to do everything. But we're not the people who should be helping you figure out what you can do within your own company to protect yourself. Hire good people. Check them out before you hire them. What you have to realize is that most IP theft is done by people you know. It's done by your employees, it's done by your manufacturers, it's done by your vendors, etc. So it's your job to be aware of that sort of thing. Now to the more generally thought of aspects of IP protection: patents, trademarks, and copyrights. I'll very briefly explain what each of those are and how those can help you in China. Now, patents in China, there are two main kinds of patents in China. They're what are commonly called utility patents, and that's what people usually think of when they think of patents. Something like an iPhone has all sorts of utility patents. That's the patent, the mechanisms, etc., that are patented and therefore protected from the outside world. Now, one of the mistakes we commonly see is there's this belief that if you have a patent, let's say in the United States, you have a patent in the entire world, and it's not that simple. In fact, it can be very complicated. And so it's very important to talk with your patent lawyer about where you have protections. And when you go to your patent lawyer, let your patent lawyer know exactly what your plan is for your product. A lot of times we'll get calls from someone and they'll say, you know, they have a US patent. And I'll say, okay, how long have you had it? And they'll say, well, for about 15 months. And then I'll say, well, now you're manufacturing in China. It would be good if you had a China patent, but you can't get a China patent because China doesn't allow you to file for a patent more than a year after you've gotten one in another country. Did you talk about this with your patent lawyer? Because if you did, that lawyer really should have told you these things. And a lot of times they'll say, no, I just told them about our product. I didn't tell them that we were planning to manufacture in China. And it's like, well, sorry, I mean, now you can't register the patent in China. Now, that's not necessarily fatal, but it's a good idea to at least have an opportunity to talk with your patent lawyer when you're getting your patent about what you should be doing in countries outside of your own. The second thing that can protect you is trademarks. And trademarks can be very effective protection, and they're very underrated, especially among people like those who come to HAX, because you're inventors, a lot of you are engineers, you think patents are everything. But trademarks, in some ways, can be more valuable than patents. A lot of times we get contacted by companies in the United States, let's say, and they're trying to get something removed off of Amazon. And they'll say, look, this product violates my patent. Tell Amazon to take it down. Well, you go to Amazon and you say, this remote, it violates the patent on my remote because inside it's got this mechanism that can click 3 times or whatever. And Amazon's going to say, I don't understand that. We're not patent lawyers. You need to sue the patent violator and win, and then come back to us and we'll take it down. That's the general response from Amazon when you have a patent issue. But if you go to Amazon and say, I've got this remote control and it's called Panasonic, and I have the trademark for remote controls in the United States for the name Panasonic, some clerk at Amazon can look, Panasonic, look it up, XYZ company has the trademark, and they'll take it down within about 48 hours. So it can be very valuable that way. It's the same way to get product taken down off of, let's say, Alibaba, Tmall, etc. Most of those sites have become very good, believe it or not, at taking down product that violates your trademark. If you've got a trademark certificate in China for your trademark and someone's violating it, they will take it down right away. Now the problem is that Chinese copycats are realizing that, so more and more they're getting away from directly copying your trademark, and they're just making a product that looks very much like yours, and they hint that it's yours, but they don't use your name anywhere, so there isn't a trademark violation. Because trademarks are used, I should have said this earlier, they're used to protect usually your brand name or your logo. So let's say the name Panasonic would be a trademark. And then there are copyrights which protect what are generally referred to as content items. Books, movies, music, photographs. And they can be helpful sometimes because, for example, we have a case right now where we got something removed off of Amazon because the photograph of the product was our client's photograph, and we were able to prove that to Amazon and therefore got it taken down. Now,
Dan, let me comment on that real quick. On copyright, copyright has not been used very well by foreigners in China, but she was telling me that a HAX product was recently, just very recently, copied in China, a HAX product, and it was a toy. And we very effectively use copyright to protect toys. You just register literally a drawing or a photograph of a toy, and we find that Taobao and JD.com and all those sites are very good if we come in with that toy and show them that we've registered the copyright for that toy. We do it for several companies, and it's very, very effective, but only if you did it. Right. If you thought about doing it and you didn't do it, it doesn't work. But if you copyrighted the design, the picture of that toy, it's really one of the most effective ways to protect toys and plush animals and a lot of things that we make in China. People think of copyright as books, but that's not correct. Copyright works very well with toys and video game characters.
Yes.
Characters in video games. Copyright's very, very effective in that area. So it just fits with something that's going on in HAX right now. And if they had filed a copyright, registered a copyright, that toy would be protected and it wouldn't have been copied.
And even sound from a video game or sound from a song, that can be copyrighted. Now, one of the things, though, that's interesting about these takedowns on Taobao is that if you're going to get something taken down on a Chinese website, you really do need it registered in China. Now, copyrights are interesting because technically you shouldn't have to register the copyright in China in order to have a copyright. And that is the law in China, but most of the websites don't, and this is true of a lot of websites in the US, they don't really understand the law, so you really do need to show them that you actually registered. I'm going to tell a little story. Whoops, I don't know why that happened. There we go. A little story about a client of ours, and I should say, forgive me if you've heard this, because I know that a few of you did hear it because I told it earlier today, but it so well illustrates the advantage of doing things right in China and also illustrates some of the disadvantages when you don't do things right. We have a client right now. Fortunately, they were not our client until the problems arose, so we can't be blamed for the problems. But they went to a sourcing company in the United States to manufacture a particular kind of sporting goods product. And this sourcing company in the US used a Chinese manufacturer to make this sporting goods product. And our client registered their brand name in the United States. And that is all that they did. And this sporting goods product took off. And it's been selling like wildfire, hugely profitable. And the factory A, their first factory, was not able to keep up with the demand, and the quality was slipping. So our client decided to switch to a different manufacturer. And they made the switch, and they started manufacturing their sporting goods product at Company B in China. And then all of a sudden, Company A sends a letter to Company B in China saying, you need to stop manufacturing this product, and we're going to stop it from leaving China at customs because we have a design patent on your product. And they did. They had gone off and registered a design patent on our client's product. Now, I said there are two kinds of patents. I talked briefly about utility patents. The other kind of patent is a design patent. And a design patent really is what it says it is. It's a patent on the design, the look of the product. So I could, let's say, get a design patent on these shoes if I develop these shoes because it's the look of the shoes. Now, the problem in China, although some would say it's not a problem because there are other countries that do it this way also, is that you can get a design patent for pretty much anything. What I always say is I could design patent my socks. In Australia, which has the same system in China, which is a system that does not review the patents before granting them, does not review the design patents, supposedly, and I learned this up in Beijing because the head of our Beijing office is an Australian lawyer. He told me that somebody in Australia just proved that you can design patent everything, got a design patent on the wheel. But the thing is, what's happened in the last few years in China is that Chinese manufacturers are using design patents very offensively. So they're registering design patents that they're not entitled to so that they can then drive to block it. So what we have had to do in this situation is we filed a design patent challenge against Company A here in China saying you cannot get a design patent on this, not because it's not patentable, but because we invented it and developed it, not you. So we've had that hearing and we're waiting for the results on that. Well, our suing them in China, as we suspected it would, didn't make them very happy. So what they then did is they then flipped around and started selling our clients' sporting goods product on eBay and Amazon, etc., at about 25% less than us. So they're making and selling the exact same product. So that's a very bad situation. So we then sued them in Seattle. Our basis for suing in Seattle was that's where Amazon is. And we knew someone would bought the product from them. That was another basis. So we sued them in Seattle for trademark violations because our client did have the trademark in the U.S. and for copyright violations. They then turn around and sue our client in Texas, which is where everyone likes to bring lawsuits for patent violations in the U.S. because it's such a crazy good place to bring patent lawsuits. So they sue in this rural town in Texas, saying that we have violated their design patent in the U.S. because they were able to take their China design patent and convert that into a U.S. design patent before our client could get their design patent filed. So now we have a lawsuit in China, a lawsuit in Seattle, a lawsuit in Texas, and we know for a fact they're going to be suing our client again in Texas on another patent. So we're fighting 4 lawsuits, and it's costing our client a fortune. And the reason I bring this up is because we always hear from people, well, you can't enforce these things in China, you know, there's no point, et cetera, et cetera. Well, there is a point, because yes, enforcement isn't 100% in China. It's not 100% in Illinois either, but it's a lot better than nothing. And in this situation, if our client had registered their trademark in China, if our client had registered their design patent in China, none of this would ever have happened. And it would have cost them a heck of a lot less if they had done those things than the situation they're in now. These 3 cases, we've got a trademark litigator working on one, we've got a patent litigator working on one, we've got one of our China lawyers working on the design patent challenge. We have a young associate helping those 3 people out, and then I'm interfacing a lot with the client. So essentially we have 5 lawyers working 3, 4, 5 days a week on these cases, and that's not a good situation. But, as I said earlier today, to a large extent, this company's lucky, because most companies that call us up in these situations can't afford it. So we get calls probably about 1 a week from a company that has done nothing and has almost no shot at getting their product back, and there's nothing we can do to help them that's not going to cost a huge amount of money. And so basically, their company just disappears and their product just disappears because they have no way to stop what's going on because they haven't prepared for it. And you've got to prepare in advance. And one of the other things you need to do to prepare is to use the right contracts drafted appropriately. And by appropriately, I mean appropriately for China. So what are the contracts that usually come into play when manufacturing in China? There are 3. N&N agreements, product development agreements, and manufacturing agreements. These are the 3 main ones. An N&N agreement is our term for a non-disclosure agreement. There are 3 N's. One is non-use, one is non-circumvent, which means they can't go to your customers or clients and go around you. Sometimes that doesn't matter. In fact, a lot of times it doesn't matter. A lot of times it really does matter because a lot of times American, European, Australian companies, they have their Chinese manufacturer ship the product directly to their retailers wherever they are in order to save money. And then the third N is for non-disclosure. American style NDA agreements do not work for China. They do not work for China at all for a lot of reasons. One, they're usually not comprehensive enough in terms of what they're going to protect you from. They'll say you can't disclose it. Well, okay, I didn't disclose it. I'm just manufacturing it. And, you know, I'm manufacturing and now selling it. But they'll argue that's not disclosure. Number two, they usually have a provision saying that the disputes will be resolved in the United States. And I'll talk more about why that's usually a bad idea, or some other country outside of China. And they usually also don't contain various other provisions that actually make them work well for China. And I'll talk about that in a minute as well. The second thing is a product development agreement, which is sometimes necessary, sometimes not necessary. And at some point I'll probably call Steve up to talk about those, because he's the person on our firm who always writes them. And they can be very complicated agreements, but I'll tell a story about that, which is that they have become a lot more important over the last few years than they used to. In the old days, 10, 15 years ago, our typical client was somebody who was having socks made in China or having rubber duckies made in China. There wasn't much product development, if any at all. So you didn't need a product development agreement. Nowadays, we'll get people who call us up, and we've had 2 of these in the last 6 months that are very simple. One involved an electronic device. The other involved a particular kind of lighting system. And these people called us up. In both instances, they had been working with a very large, very well-known Chinese company, 2 different Chinese companies. They've been working with those companies for about 2 years. And they called us up and said, you know, we've been working with company A for the last 2 years. They've been fantastic. You know, everything we've tried to do, they've helped us. We now have the product ready to go. And we'll say, okay, what do you mean you've been working with them for 2 years? Well, for the last 2 years, we've been honing our product, and now it's ready to go. We're ready to start manufacturing. We're ready for a manufacturing agreement. And then we'll say, okay, what have you paid these companies over the last 2 years? And they'll go, we haven't paid them anything. They've been great. They've helped us for the last 2 years. Well, at that point, if there's someone else in the room, we're usually looking at each other like, oh no, here we go again. And we'll say to them, okay, so now you're ready to manufacture, but our fear is that they think, the Chinese company thinks that they own the product because they developed it and you haven't paid it. And they always go, oh no. There's no way, that's not going to happen. In one of the examples, which I didn't even know this until today, Steve was telling me about it in one of the smaller sessions, the client had already gotten a contract from the Chinese manufacturer that said, we, the Chinese manufacturer, own the product. And the client thought it was a mistake. He thought that the technical people obviously weren't talking to the lawyers. And that's usually the reaction they give when we say, wait a second, we're really worried here. And they're like, no, don't worry. You know, we talked to so-and-so 2 years ago. Well, in every single instance we've ever seen like this, what ends up happening is our client goes back to the manufacturer and says, you know, here's the manufacturing agreement, or I'd like a manufacturing agreement that makes clear I own the product and you're going to manufacture it. And the Chinese company, I don't know if they're being sincere or not, I actually think they might be, they're saying, what do you mean you own the product? We just spent 2 years building this product, and we're going to let you sell it in the United States as our distributor for 6 months. And if you do a good job, we'll let you continue. And if you don't, you're gone. And then they come back to us and say, look, you know, you got to help us here. It's like, help you? You don't have a single document that can help you because you don't have anything making clear who's going to own what. And so we're now, well, we always have, but the key to this is to have a product development agreement that makes clear who's going to own what. You know, are you going to pay for this? How are you going to pay for it? Are you going to pay $150,000? Are you going to pay by having the price of your product be $1 higher until $100,000 is paid? But if you're going to own that product when all is said and done, you need a contract that says that. And that's what the product development agreement does for you. Now, the manufacturing agreement, that is necessary virtually all the time. In that agreement, we put in all the substantive provisions from the NNN agreement. So it's very clear that your Chinese manufacturer cannot compete with you, that it cannot go to your customers. But also what goes in there are things like delivery dates, quality standards, specifications. What happens if they don't meet the specifications? What happens if they don't meet the quality standards? So now I'm going to talk about contracts generally, but all these apply to the 3 contracts I talked about earlier. What constitutes a good contract with a Chinese company? Well, number one, it should be in writing. This is not the United States where you can have oral contracts. In Chinese courts, they want a writing. They want an old-style contract. Ideally, it's been chopped or sealed by the Chinese company, but at least it should be signed. It should be when I say one language, there should be one official language. A lot of people like to write contracts, and a lot of lawyers do too, that are dual language. Now, by that I mean not just dual language, but they'll say that there are 2 official languages. We write our contracts in Chinese and English, but we're always clear as to which language controls, which language is the official language. I always used to say, I don't know why lawyers like dual language contracts. Actually, it was at the American Bar Association. A lawyer in the back raised his hand. He goes, I know why lawyers like dual language contracts, because if there's ever a problem, we can charge twice as much. And he's right, because you have just right there doubled the likelihood of ambiguity, because you have more words to deal with. And you can argue, well, you know, in Chinese it says the, in English it says and. And you know, can argue about every word. And not only that, if you're going to have a dispute, let's say you have a dispute in China where the court is in Chinese, you're still going to need somebody who's really good in English to explain the English side. And if the dispute is before an arbitrator in English, you're going to need somebody who speaks Chinese, because you're going to have to explain the Chinese side. So usually it means you're going to be able to charge for 2 lawyers at any dispute. But the reality is, it's a mistake. You can have a dual language contract, but the contract should state very clearly what language is in control.
Worse than that. Here's what happens in China. Chinese courts won't do English. They don't care if it says dual language. They will not do English. American courts won't do Chinese. I mean, that's perfectly natural. But in China, the translation from English into Chinese is done by a court-appointed interpreter. It's not done by you. And that court-appointed interpreter is usually a 74-year-old ex-military guy who doesn't have a clue. Now, if you say the governing language is Chinese, and you did the translation, which is what I do, I did the translation, then you know the translation's right. And you don't get that problem of an incompetent translator arguing about. Okay, so that's why I do it.
Well, and what that means essentially is that you may find yourself suing in a Chinese court or in front of a Chinese arbitrator on a contract, if it's an English language contract, that's going to be translated. So you're bringing a lawsuit on a contract that you don't even really know what it's going to say. So you can bring a lawsuit in a Chinese court based on an English language contract, and it's going to be a different contract by the time it actually goes to trial, because it'll be translated. Now, you want the contract to be in excruciating detail because in China, basically, if it's not clearly in the contract, it's pretty much like it does not exist, which is what almost happened with my PowerPoint there for a second. So an example I always give there is a story about a Shanghai executive. This story is from so long ago, I'm not even sure anymore whether it ever really happened or not, but I still tell it anyway because it proves the point. So you've got this executive in Shanghai, and he's renting an apartment. And he has a nice office chair, and it breaks, because most of these nice apartments in Shanghai are furnished. And his office chair breaks. So he goes to his landlord, and he says, you know, will you fix the chair? And the landlord continually doesn't fix the chair. And then 3 or 4 months later, it comes time to renew the lease. So he says to the landlord, I'm not going to renew the lease unless you put in the lease that you're going to give me a new office chair. So the landlord puts in the lease, I will give the tenant a new office chair. And the tenant signs the lease. A few days later, the landlord comes in with, you know, a $5 folding chair instead of the $600 office chair. And the executive says, I don't know what I was thinking, I should have been clear. Now, when I tell this story before lawyers in the United States or in Canada or Britain, I always say, you know, what would happen if the executive were to sue the landlord in the United States? Well, in the United States, the executive would win because the court would say, well, everybody knew what he meant. The court would infer that they meant a comparable office chair. But it's not that way at all in China. It means a chair. And we get, we see contracts where people say, I want to sue this Chinese manufacturer for giving me bad quality. And we'll say, okay, does your contract provide for what the quality specification should be? And we'll go, oh yes it does. And they'll send it to us and it'll say something like, reasonable quality. Well, reasonable quality in the United States has meaning. Reasonable quality in China does not have meaning. One of the first matters I had many, many years ago was a laptop bag manufacturer the handles from their bags were breaking because they were not strong enough to hold the laptop. So we went to the manufacturer and we said, hey, you know, what's the deal here? These bags are not good enough, they're not strong enough to hold your typical laptop. And the Chinese manufacturer said, yeah, we know that. If they had wanted a bag that was strong enough to hold a laptop, they should have bought our $5 bag, not our $3 bag. And they were right. Because they paid $3 for the bag. It nowhere says, you know, there needs to be of this tensile strength, etc. So, no case. Okay, so this is going to be a little bit legalistic, but it is important. In drafting a contract, one of the first things you need to think about is what are your disputes going to be and what will be the best place to resolve those disputes. And most lawyers are trained to put in their own hometown. And there's the expression, you're getting hometown. So if I'm in Seattle doing a contract with someone in Chicago, I want the disputes to be resolved in Seattle, especially if my client's in Seattle. It'll be cheaper, I know the court's better, et cetera, et cetera. But that doesn't necessarily hold true when you're dealing with a Chinese company. And American lawyers make this mistake all the time, as do lawyers from a lot of other countries. They'll put in, let's say, Chicago as the place, a Chicago court to resolve disputes with a Chinese company in Shenzhen, and their thinking is, well, the last thing I want is to find myself in a court in Shenzhen, because I don't know what I'm doing, and it will be really bad. So they put in Chicago. there's a big problem there. The problem is that they can sue in Chicago under the contract. They can win in Chicago because the Chinese company probably won't even show up because they're not concerned. Because once you get that judgment from a Chicago court, it has no value except in the United States. And if you take that judgment to a Chinese court, they will not enforce it. Not they won't enforce it some of the time, they won't enforce it 100 times out of 100. So you have a worthless piece of paper. So about once a month or so, American lawyers call us up asking for us to help enforce the U.S. judgment in China. And we always say, no, we really are not interested. And they're always shocked because they've drafted, let's say, a Des Moines, Iowa provision. They just charged their client $35,000 to get a Des Moines, Iowa judgment, and we're saying it's worthless. So they always try to come up with an idea to get around that, and their idea is, well, why don't I just sue the company in China? And the problem is, you can't, because China doesn't enforce U.S. judgments, but China does enforce contracts, and your contract said you need to sue in Des Moines, so you can't sue in China, especially since you've already sued in Des Moines and you won, and China, like most countries, doesn't allow you to sue somebody twice. So you've got this judgment and you can't do anything with it. So that's a big mistake. But then clients say, well, I don't want to sue in Shenzhen. And our response to that is, well, I mean, you can sue in Shenzhen where, yes, I mean, the courts are not going to be as well developed, as sophisticated, maybe not even as fair as, Chicago's not a good example, let me pick another city, as in Seattle. But it's really your only choice. And so seeing as how it's your only choice, you should be writing your contracts to fit the venue in which you're going to be dealing with.
And that'll give me a chance to say, all of you guys that have signed an NDA in China, go home tonight and take a look. I would guess 100% are worthless. Just go home and check, because they're all enforceable in Seattle or Cleveland or London or Stockholm or Hong Kong. And if that's true, they're worthless. So just go home and check. Just take a look in your
Hong Kong.
Worthless. They will not enforce Hong Kong judgments. Hong Kong is a different country.
Now, Hong Kong arbitration is not, it may not be the best, and it may not be good, but it's not worthless. And arbitration in Stockholm,
I don't agree with Dan on that.
Arbitration in Stockholm and Seattle, or Vancouver and Toronto, those are not worthless.
But just look at the expensive NDA that you did. Just take it out of your drawer and look at it. And look at the enforcement provision. And in my experience, in the many talks I've done over the past 30 years, if it's an NDA, if it's called an NDA, which is already worthless because it's based on trade secrecy, which doesn't work here. If it's enforceable in Cleveland, and the company has no assets in Cleveland, which they don't. Their subsidiary might have assets in Cleveland, but they don't. It's worthless. Okay, just go home tonight and just take a look.
But a Hong Kong company that you're working with.
Hong Kong,
that's different.
But if it's
We're
written
talking about
enforcement
PRC,
in Hong
People's
Kong.
Republic of China.
Right, if you're dealing with a Hong Kong company, and you have a contract that says Hong Kong, that's fine.
What about NDA that I downloaded from China law blog?
What do you mean?
There is NDA in the blog.
No, we don't do
No,
NDAs.
there's a China law blog, your ChinaLawBlog.com, there's a ChinaLawBlog.org, I don't even know if they're still around. They may have NDAs.
Really?
Yeah, but
We've never written an NDA.
About the board game NDA from China? No?
no.
Okay.
We've never written an NDA.
Well, we've written NDAs for Seattle.
Oh, no, I
in
mean
the
for
US.
China. I mean for the People's Republic of China. We've
Right.
never written
No.
an NDA.
Okay,
Can we just jump to Hong Kong really quick? So because we're in Guangdong, a lot of the business offices are in Hong Kong, and the factory itself is in Guangdong.
Right, that's
So-
a tough one.
Okay.
And we deal, that was asked earlier today, and we deal with that all the time. The problem is, in those situations, sometimes the Hong Kong company will say, I'm not going to let you do a contract with the PRC company. It has to be with us. And then you have to decide, is that okay? Now, and then the biggest factor is, I mean, if it's a big Hong Kong company with assets, it's not that big a deal because Hong Kong has a very good court system and you could sue them for damages, assuming that the contract with the Hong Kong company is written in such a way that what the PRC subsidiary does is makes the Hong Kong company liable in Hong Kong. But a lot of times, the Hong Kong company is nothing. A company came to us once saying, you know, we got this really bad quality product, we want to sue the company in Hong Kong. And they were all ready to go. And I said, well, wait a second, let's see who this company in Hong Kong is. $1,000 worth of research told us it was some crappy office, 2 people, two old computers, nothing really in their bank account. So it all depends. But a lot of times you're better off with, if you can't figure out what you need to know about the Hong Kong company, the advantage of the PRC company is you at least usually know that they're licensed here and they own a big factory.
Yeah, the thing with Hong Kong, I have a lot of Hong Kong clients who work in the sourcing and manufacturing area. Give me their Hong Kong, right? And they have an agreement with their bank. First of all, they own no properties. Their office is rented, everything is rented. And they have an agreement with their bank and clients will tell me when they're looking at a company like this, well, this company does $50 million a year in turnover. They've got to be good company to sue, right? But they have an agreement with their bank that the money stays in their bank account no more than 24 hours. 24 hours later, that money is gone. And second, you file a lawsuit, if there is any money there, it's gone the next day anyway. I mean, these people know what they're doing. And they may have tremendous turnover, but once it's time to enforce the judgment, there's nothing there to enforce it against. And so you know, even in the United States, I always tell clients, don't file a lawsuit against a company that you can't enforce the judgment against, right? If they own tremendous amounts of hard assets, you can enforce the judgment. But if they're just rented office space and sweep account, bank account, where the money goes from Hong Kong to the Caymans or to Virgin Islands or someplace like that, or the Isle of Man, or the Isle of Guernsey, or one of those places, there's no benefit, there's no value. And if it's a Hong Kong company that's not a manufacturer in Hong Kong, which now no longer exists, you can almost be certain that they're guaranteed that nothing is remaining in Hong Kong. It's getting out of, that's the point of being in Hong Kong,
Right.
is to be able to get your money out of there to a British, old British sovereign group kind of tax shelter. So they don't keep it there, they get it out. So that's just the way it is. You want to sue somebody that's got, you know, if you sue in China, they've got a factory.
Well, and also
You've got asset that you can go against, right? Because there's a factory there. And that's what you want.
We put in our contracts what are called contract damages, and these can be hugely effective in China. So there might be a provision that says if Chinese company A does B, $100,000 damages. Now, the reason that's so effective is because that provision allows you to go to a Chinese court and freeze the bank account of the Chinese company to the tune of $100,000. More importantly, Chinese companies know this and they fear it. And so this provision is one of the best provisions you can have for keeping the Chinese factory in line, preventing them from breaching the contract, which is really your goal. Because I'm always asked, American companies always ask, why bother with a contract with China? I've heard you can't enforce it. Well, there are three main reasons you do a contract. Three main reasons why you want a good contract. And in countries with highly developed court systems, we tend to focus just on enforcement. But there's clarity, which is very important because you're dealing in a cross-cultural context and a lot can get misunderstood. Classic example, because it happens probably 90% of the time, is our client will say, oh yeah, they told me they can make this hugely complicated device and get it to me 15 days after they get the purchase order. And so we go, okay. So we put in the contract, hugely complicated device will be delivered to Omaha, Nebraska, 15 days after the purchase order is received. And every day it's late will be contract damages of 1% of the purchase amount or something like that. We send it off to the Chinese company. They always come back, they go, no, can't do that. And then our client goes, well, you said you could do it. No, can't do it. So then we say, well, what can you do? And they'll say 45 days. So then we say, okay, 45 days. They put in 45 days. At least now our client knows they're not going to promise all their downstream customers 20-day delivery, so the risk has been ameliorated, but they've achieved clarity, and that's important. The second thing is prevention. If you have provisions in there that scare the Chinese company to not violate the contract, that is powerful. And then there's enforcement, which if you have to enforce the contract, you've already lost because it's going to be costly and you're not going to get all your money even on a good day.
Well, in that storytelling time, right? We hear all the time, you can't enforce contracts in China. Well, that's just a false story. But I got to tell a story, right? There's a really smart German guy I know in Qingdao, and one night we're out at the local Qingdao watering hole, and he says, Chinese contracts aren't worth the paper they're written on. You can't enforce them. And so being the kind of obnoxious guy I am, I said, show me that contract you're talking about. I didn't let him get by with it. I said, show me that contract. And I said, I know. He said, I know, because I have one and we weren't able to enforce it in China. And he's run, all around telling everybody, China's worthless. This Dickinson guy, get him out of town. He's just cheating you. Show me the contract. Okay? Well, it was written by a London lawyer, and it provided English language controls, and the exclusive jurisdiction is London. Right? That's what it provided. Well, yeah, that's not enforceable in China. It's not, but it's not enforceable because you made it not enforceable in China, right? But he's going around saying, oh, China's a terrible place. I can't enforce this contract in China. Well, almost every time Dan and I hear that story, oh, you can't enforce contracts in China, it's because the contract was written in a way that it could never be enforced in China. It just couldn't be. You never get to the point of having a lousy, incompetent judge decide the wrong way because the contract couldn't be enforced in China because of a provision that they insisted on when they negotiated. They're really proud. Oh, I forced those Chinese people to accept British law and enforcement in London. I made those guys do it. Right? And I'm so proud of myself. I mean, I have a Danish friend in Qingdao right now, really proud. He just spent $300,000 on an arbitration in London. And I told him, don't do that arbitration, because you won't be able to enforce that arbitration award in Qingdao. And now he's got the award, it's beautiful, right? But he can't enforce it. And he's the one, I told him when he was negotiating the contract, don't do this. What? Don't insist on London. Don't insist on English. Don't insist on British law. And he said, oh no, my British lawyers tell me this will work perfectly. Well, it didn't happen. It's never, in my experience, I've only been here since 1981, so I don't have infinite experience, right? But I've never once seen a case where people said, oh, you can't enforce contracts in China, where it wasn't the fault of the person who did the contract, in my own personal experience.
Well, and then the response to that oftentimes is, well, what about corruption? Aren't Chinese courts really corrupt? And especially when I'm in China, I like to talk about corruption in Russia because it's a great example of how Westerners don't really understand the way corruption works. Many years ago, I had a case in Vladivostok, Russia, and our client had a really good contract, and if they had sued in the United States, it would have been, let's say, a 95% chance that they would have been awarded $2 million. Unfortunately, or fortunately, because it wouldn't have made sense, because Russia doesn't enforce U.S. judgments either, the contract said they needed to sue in Vladivostok. So we bring on a Vladivostok lawyer who tells us that there are 15 judges in Vladivostok, and 9 of them are corrupt. And although a little sidelight there is that the corrupt judges in Vladivostok, or so I've been told, are very honest. If you pay a judge $50,000 to throw a case for you, and then he or she realizes that it's just too risky to throw the case, they'll always give you your $50,000 back. So you're safe there. But, so we've got this case in Vladivostok for $2 million, and we get one of the corrupt judges. So the client says, well, let's shut it down. There's no point. Well, there is a point. Westerners seem to think if the judge is corrupt, then everything's over. But it does not work that way. So in this case, we worked with the Vladivostok lawyer, and he basically explained, look, this is a slam dunk winner for us. It's going to cost the Russian company a lot of money to buy the judge. It's going to probably cost them $400,000 because this judge does not want the Court of Appeals, when we appeal, to look at the decision and say, what the hell were you doing there? And start suspecting. So there are risks involved, there's money involved. So $400,000 right there. Then when it goes to the Court of Appeals, it's going to be outside of Vladivostok. It's going to be in Khabarovsk, I think it is, where the Court of Appeals is. And now there are 3 judges, and they're not even local. So this person's now going to have to bribe 3 judges. And maybe not all 3 of them are corrupt, but really only needs to bribe 2. But so he has to bribe 2. So that might cost him another $600,000, $700,000, $800,000. Now we're up to $1.1 million just in bribery fees, not to mention the risk. We ended up settling the case for $1.2 million. Now, if it had been in the United States, we probably would have settled it for $1.8 million. But $1.2 million is a lot more, $1.2 million to be precise, than they would have gotten if they didn't have a good contract. So corruption isn't an on-off yes-no switch. It's we need to have a different settlement strategy switch. So corruption, it may be out there, but it's not a reason not to have a good contract. Okay, so
that would be, in China, the judges aren't corrupt in towns like Shenzhen and Shanghai and Qingdao and Beijing. The problem with judges in China is they're incompetent, not that they're corrupt. They're lazy and incompetent, but they're not corrupt. And so what we find is that when we get a bad decision at the lower court level, it's not because the judge was bought off, it's just because the judge was playing pool in the back room and just, did a randomized decision. And then we appeal it to the high court and we win.
But there is one thing that's very different about Chinese courts than most Western courts, and that is, I'm not making a value judgment here, it's just a difference. They're not as legalistic. They're much more focused on equity. So if you have a situation where in the United States, let's say you have a low-level employee that causes a major problem that costs somebody $3 million, and the company that was damaged to the tune of $3 million sues the U.S. company, they're probably going to win. In China, they might look at that case very differently and say, this company, how could they can't control all 5,000 of their employees. There was a lower level employee. We're going to treat it differently, blah, blah, blah. And then Americans get, or Brits or whatever, they get these decisions and they say it's corruption. But it's not corruption, it's just a different way of looking at the case. And the judge would almost certainly reach the same decision if the plaintiff were a Chinese company. So it is important to know the differences in the way the courts operate. I'm having all sorts of problems with this PowerPoint. I've gone on long enough. Should we open it up for questions or?
Yeah, thank you very much, Dan, for we have some time for questions. No, it's a lot coming up.
Dispute resolution or jurisdiction. So quickly, can you describe how a contract should be written? Are you always following the money? Are you always going after the major assets of the corporation, of the company doing business? Will it be a factory? Will it be a trading company? You don't